So a very good evening to all the innovators, all the aspirants of patent agent exams who wish to become patent agents after some time. Exams are very near, but yes, it's possible to prepare in this short span of time because a proper systematic planning for the examination can really bring good results. And yes, we can discuss how we can crack the exam by proper systematic planning of paper 1 and paper 2 and also the viva voce for the patent agent examination, because it's based on act and laws, and if we can understand those things in a like very applicable manner, and also can prepare for the paper 2 by understanding how to answer the questions asked and how to exactly draft the claims to fulfill the requirements of examination, we can crack the examination. So it's nowhere too late. Yes, exams are near, but preparation in a very systematic way can bring the good results. So this is Dr. Prachi Pandey. I'm a registered Indian patent agent, and also I'm looking after startups and entrepreneurship as a deputy director and professor in Center of Startups and Entrepreneurship in KPGU Vadodara. So I just wish to tell you something about how to prepare for patent agent examination in a short span of time. And so for that, in this session, I will discuss some questions of patent agent examinations, because act, laws and rules are definitely there. We can discuss, but in this session exactly I will share how it can be prepared, how the questions could be answered, and exactly what type of questions are being asked, what is the eligibility, and how we can prepare, what is the structure of examination. So a brief overview over all patent agent examinations questions, eligibility will be discussed today. So I will be happy to answer any questions asked by you that you can type in comment box, and I will try to answer them as soon as possible. So let's start with the eligibility part, like who are eligible to become patent agents. So first of all, you must be an Indian citizen for becoming an Indian patent agent. You must be at least 21 years old. You must have completed a degree in either science, engineering or technology from any university established under the law currently in force in the territory of India. So any university, even private, government, any kind of self-funded, there is no bar. Uh, or you must possess such other equivalent qualifications as given by central government. Yes, of course, final year students also can apply in this respect as long as they can show their degree certificate with all their marks within 2 months of the publication of patent agent examination result. So suppose today result is published, within 2 months they have to show their degree. So even final year students can apply. So a BSc student, MSc is a higher one, but degree means graduation. If you are highly qualified like a postgraduate or PhD, so it will be good, but minimum is the graduation degree. So BSc, MSc, BE, ME, BTech, MTech, BPharm, MPharm, PhD in any of the streams of engineering, pharmacy, or like science, or PhD of any stream. And another, this is the important, that is minimum. And beside that, you have to qualify the patent agent examination. So examination is must to be qualified, and 50% marks must be brought by you. And another clause is that if you have not done all this, at least you must have served as an examiner or as the controller under section 73 for a period not less than 10 years. So if suppose somebody is patent examiner or patent controller and served for a period of 10 years, they can directly become patent agent. So you can ever imagine how this examination give you such knowledge and expertise that you become just like equivalent to controllers or the patent examiners. So in such both are considered equivalent. So if you are clearing a patent agent examination, is definitely a matter of honor, pride for you, and definitely you will become legally eligible to apply for patents for other people. And another thing, after qualification of patent agent, you have to pay the necessary fees. So necessary fee for registration as a patent agent. So exam structure. Now, as we know that if we are eligible for patent agent examination, so on the portal of ipindia.nic.in, Clear? So that is www.ipindia.nic.in. Whenever you open it, you will see that there is a proper link where you can fill the form for examination of patent agent or trademark agent. It is there. So you have to fill the form, you have to pay the fees for examination, and then you will have your admit card or like e-admit card generated that you can use, and you can select the centers. So centers are in the metro cities as well as some other big cities, Ahmedabad. So you can select the center near to your city and you can appear for examination there. So after filling the form and giving the fees, whenever your admit card is generated, then there comes the point of examination. So examination consists of paper 1 and paper 2 and viva voce. Paper 1 consists of 100 marks. That is covering the Patent Act and rules. Examination is for 2 hours and it is objective type. Multiple choice questions having one or more than one option. So sometime it is of one option or more than one options are there. I'm showing you the question paper of paper 1 so that you could be acquainted how the questions are being asked. Then comes the paper 2. Normally, examination takes place in a single day. In the morning shift, 2 hours. After lunch break, again, the paper 2 takes place. So, in a single day, for 2 hours and 3 hours, this time would be spent in a single day. So, you have to be fully prepared because there would not be much gap between paper 1 and paper 2. It's in a single day. So, paper 2 consists of 100 marks, where drafting and interpretation of patent specification and other documents are being asked. This is totally descriptive type, and you have to write the answer of questions as well as you have to draft the claims. Uh, I suggest that paper 2 is more tough because here you will find shortage of time. So just I will tell you exactly how to write the answers so that you can save the time as well as you can fetch some good marks. And whenever you clear the paper 1 and paper 2, results are declared for paper 1 and paper 2 on the website of IP India, and there the selected candidates will be called for the viva voce. Viva voce is of 50 marks, and total means like whenever you qualify the theory and viva voce both, cumulative marks will be counted, and then you will be finally qualified. So I just say that in the first paper and especially try to score higher and higher because this is objective and multiple choice based on act and rules, so you can score well. Because in paper 2 descriptive, you may not score very well, but at least you can fetch some good marks so that at least you can be safe in such things. So it's better to score a little bit higher in paper 1 so that whenever the total marks are clubbed up, you will be in a safe position. And viva voce, definitely, if you have a good idea of act and rules, and also you can apply those act and rules, because in viva important is not only to remember, important is how do you apply. They can give you some cases, some situations. If you are a corporate, if you are an academician, if you are a student, how do you exactly apply the patent act and rules in your own professional services? So that will be more important. So even if you don't remember the section number or subsection number, but you know what is the law says and how the law could be applied in application or profession, then this will be great. Because even I know that even nobody can remember all the subsection number and these things. But if you can remember the exactly what does it say, you can use those laws in the application purpose. So yes, so let's see the paper 1. How does it look like? So paper 1 consists of can say that this paper 1, you will have some questions like this. Suppose this is the part A. So part A consists of 60 marks, part B consists of 10 marks, and part C consists of 30 marks. Part A, you will see that only one answer is correct. Part A. This is a very, I can say that very scoring portion where you can score much marks because only one answer is correct and it's easy to answer. So here you can see that part A is consisting of 60 marks and it has 30 multiple choice questions. So each question carries 2 marks. So it's good that you attempt all and clear all. So suppose one question: which section of the Patent Act refer to powers of controller to make orders regarding substitution of applicants? So this is section 20. So in this way it is being asked. Now part B. Just a minute, I'm scrolling to part B. So okay. So part B. Part B is little different. Part B is of 10 marks and consists of 10 true false type questions of 1 mark each. So it will be of true or false, but it's very remarkable that for each question out of 4 options, only one option is correct. Answer should be given A, B, or C, or D. So what are A, B, C, or D? So this says, suppose statement 1 is true, 2 is false. Statement 1 is false, 2 is true. Statement 1 and 2 both are false, and statement 1 and 2 both are true. So these are 4 options given here. So now suppose this is question number 31, and it has given a particular question and along with this 2 options. So suppose these are 2 sentences. Okay. So what could be the answer? 1 is true, 2 is false, or both are false, both are true. In this way, we have to select the option, either option A or B or C or D. So everywhere you will see there are 2 sentences given. You have to analyze the 2 sentences and decide which sentence is true, which sentence is false, and if both are true or one is true, one is false, what would be there? So first of all, just go through, read the sentences. Answers are already given, so you can see the answer here. So you can first write in your paper which is false, which is true. Clearly first write as it is written here. Then if suppose both are true, 1 is true, 2 is true, then your answer would be 1 is true, this 1 and 2 both are true, so answer would be D. Okay. Suppose the situation is that first is true, another is false, your answer would be A. So in this way you have to select. So this is also easy to be done because analysis becomes much easy because you have already the answers given. You have to just recognize which is the true, which is the false. So this is also good to answer. Now I'm coming to the part C. So part C is what? It consists of 30 marks and consists of 10 multiple choice questions. Each question is of 3 marks. But here, the problem is that more than one answer is correct. So you should have a quite understanding about the application because these questions are mostly application based. So just for example, if any person uses his place of business, just a minute. If any person uses on his place of business the word patent office, he is punishable with what? So it is given in Act that imprisonment for a term which may be extendable up to 6 months, imprisonment or fine, and imprisonment and fine. So yes, he can get imprisonment or fine or and fine. So both could be applied or either could be applied. So these 3 are correct, A, B, and C. All the 3 are correct. Warning by the controller is not a punishment. Warning is not a punishment. So definitely you can first omit it out. So the tip to solve is that first omit out which is the most irrelevant answer and then analyze other answers. So normally whenever such punishments are given in Patent Act, normally it is not very stringent that only fine or only imprisonment. So normally these are imprisonment or fine and imprisonment and fine. And first is your elaboration of imprisonment, or normally it is not more than 6 months. So all the 3 are correct. So In this way, in the OMR sheet, you have to circle three, A, B, or C, all the three. So in this multiple option correct type of questions, you have to mark all the answers which you think those are correct in your OMR sheet. So you will be given a OMR sheet and only you have to dark circle it as done in all competitive examinations. So those answers are correct. You have to darken all the options A, B, C, or D, whatever is correct. So these are three type of questions been asked in paper one. So yes, now we will see exactly what are the questions and we will solve some questions. Okay. So first question: following person are entitled to apply for patent. Who is entitled? So this is one option correct kind of question. A person claiming to be the first inventor of the invention, legal representative of the first inventor if he deceased, and any person who is the assignee of the first inventor of the invention. So you can see this if two are correct. Suppose you are not very much sure about the third one, but if two are seems to be correct, definitely it will be all of the above because there is no option of A and B are true. So you can have some tricks in your mind along with your knowledge. I just say that you can apply some common sense, and so here the answer will be definitely D, because person claiming to be the first inventor would be definitely entitled, or a legal representative of the first inventor who is deceased. At least these two are clearly correct. Third point comes where the law and act comes. He's like a person who is the assignee of the first inventor. So yes, patent is assignable. You can assign somebody, and that's why this is also correct. So answer would be D. Now, every application for a patent shall be for. So there is a unity of invention. One product, one invention must be filed in just one patent application. If one patent application carries more than two or three inventions together, then a patent controller may say you to divide the patent application and file divisional applications. So they never allow more than one invention in single application. So every application for patent shall be for one invention only. Answer would be C. So what is the territorial jurisdiction of the Patent Act 1970? So it extends to the whole of India except for Jammu and Kashmir. It extends to the whole of India, extends to whole of India except for Union Territory and Jammu and Kashmir. It extends for whole of India and members of the intellectual property organization. So here what would be the answer? This is a kind of tricky question. So simple, it extends to the whole of India. It is written, and members of the World Intellectual Property Organization, that is also like a very understandable thing. So it is like uh, extends to the whole of India. Now comes there is a gap, and it has to be filled. So in relation to dash, in relation to an invention means that the invention is capable of being made or used in an industry. So it's very simple to answer. Capable of industrial application. Capable of industrial application, the act has written particular sentence that it should be capable to be being made or used in the industry. Another come. Intellectual property rights are what kind of right? Over the use of creation for certain period of time. So this is exclusive right. Exclusive means a monopolistic right. So questions are there. The term intellectual property covers what? What are those things? So what would be the answer? It would be uh, yes, you can even answer some of the questions if you want to answer. If you want to answer the questions, you can definitely try and answer such questions. If you are want to participate, definitely you can do that. So for this, the term intellectual property rights covers what? Yes, definitely Amrita Agrawal has given the answer, and that is perfect. Himanshu Gogia, yes, perfect. So design, logo, and equipment. Design under industrial design, logo under trademark, and equipment, medical devices are patentable. Yes, equipments are patentable. So Yes, you must have a try. All have answered very well. Smita Khare, Vande Komal, Uday Singh. Yeah, thank you very much. The policy behind the patent system is what? So here actually it doesn't. Whenever you see in the act, actually it is not there, but it is. Question is like policy behind the patent system is to encourage the inventor to disclose the invention by granting exclusive rights over the invention to the inventor. To not benefit the public, definitely no, it will not be the answer. To not benefit the public by encouraging, no. To benefit only the owner, so this would be the first answer. Now, Indian national IPR policy came in which year? So this is has to be remembered actually. Indian national IPR policy, whenever it came. Yes, Amrita Agarwal, definitely you are giving the right answer. Yes, perfectly. Number 1, 2016. Biological diversity means what? Biological diversity is biological destruction, the similarity among living organisms, the variability among living organisms from all sources and the ecological complexes. Biological destruction. Can anybody try this? Biological diversity. What does it mean? So definitely the word diversity says that the variability among living organisms. Definitely. Nidhi Shah, the Vande Komal, Himanshu Gogyar. Yes, perfect. Variability among living organisms. Answer is 3. The following can be patented. Machine process composition of matter. Very easy, all of the above. Which one is not invention? So just try it. An invention, the primary or intended use or commercial exploitation could be contrary to moral laws, a method of agriculture or horticulture, topography of integrated circuits. So answer would be above all. Yes, Himanshu Gogia, you're correct. It is all. So these all comes under section 3. So these are statutory subject matter which are not patentable. So answer is D, above all. What cannot be patented in India? Computer program, scientific theory, mathematical method. So these are actual questions normally being asked in exams. All of the above. Shri, yes. Suhi Shabir, Kirti Rani Sharma, yes, you all have answered very well. These all cannot be patented. Computer program, scientific theory, mathematical model, all are coming under section 3 statutory matter, and these are not patentable subject matter. What can be patented under Patent Act 1970? Playing a game, an invention, a scheme, an aesthetic creation. So this is an invention. What can be patented? Only invention can be patented. Playing a game, not patentable. Schemes, not patentable. Aesthetic creations are copyrightable, not patentable. So answer would be B only. Which section of the Patent Act deals with the person entitled to apply for patent? So if possible, just try this question because such questions are normally asked. So if you are preparing for patent agent examination or just aspiring for doing it, such questions are the major questions which could be asked to you. So just try to answer this. Answer would be, okay, Dr. Anita Kumari K. Yes, ma'am, you are right. Section 6 of the Patent Act. Himanshu Gogia, yes, perfect. Answer is B. Shri, all have given the right answer. Nidhi Shah, Suhi Shabir, all have written the right answer. Yes. Section 6 of the Patent Act says about who is entitled to apply for patent. Now the question. Section 7 of the Patent Act 1970 deals with what? Please try this. Okay, Kirti Rani Sharma. This answer is definitely correct. Others also please try. So yes, form of application. Section 7 of the Patent Act 1970 deals with form of application. Forms are given in section 7 of the Patent Act. Now, the question comes about something about subsections of section 3, that is statutory subject matter. Discovery of a new galaxy is not patentable under which subsection of the section 3? 3C, 3K, 3D or 3B? Please try. Okay, so the first answer I received from Nidhi Shah, and yes, it is correct. As per section 3C of the Patent Act, the discovery of new galaxy is not patentable. So whenever we will go through all this, this is the most important section, section 3, that is patentable, and there is a proper way. Actually, whenever I last year I taught some of the students of patent agent examinations, and they cleared also with good marks. I gave them a certain trick of remembering all from starting from subsection A to others, exactly how to remember. uh, so there is a proper word through which we can exactly correlate the particular subsections. So in this way, section 3C, discovery. So in this way, we have actually matched certain words of the not patentable subject matter with the subsection letter. So in this way, we have mapped it, and it was so easy and fun to remember, that everybody actually remembered section 3, and it is very easy to do that. So try to match it in that way that you can exactly remember all the subsections, because this is the most important part. Now, method of committing theft is not patentable in accordance with one of the sections of the Patent Act 1970. Find out the relevant section. 3C, 3B, 3A or 3D. Which is the section? So I am waiting for the answer. It is in very early, just for a hint. Okay, try, please try. Some, like, all should try, so that so the answer is B. Nidhi Shah has given the right answer. Answer is B. Section 3B. Section 3B of the Act has said it. That is, method of committing theft is not patentable. Okay. Now, a researcher finds an idea of recycling of biodegradable plastic. How does he proceed for patenting his idea? What can be done? So, he needs to publish in the scientific journal and has to wait for invitation from patent office? No, not at all. He needs to submit provisional specification and subsequently to file complete specification before patent office. So it's very easy. It's B. So B is the correct answer. So this is just based on some common sense. Is like, you can really, some questions you will really find of this type. So you just save the time and go fast as possible. Now, definition of capable of industrial application in relation to an invention as per the Patent Act means invention is capable of being made or used in industry, capable of being manufactured in industry, capable of being sold by an industry. So what is the answer? We have just now discussed it a few minutes ago. Yes, Nidhi again, you are performing very well. So invention is capable of being made or used in the industry. So that's the industrial application. Answer is 1. Shri Rohita, yes, you are also right. Amita Agrawal, you are right. Yes. Okay, next question. Which of the following are not patentable as per the provision of the Patent Act? A surgical instrument, a computer program per se, discovery of any living thing, or a clock having 10 hours and each hour divided into 100 minutes. What do you think? Which is and are not patentable? So here answer could be more than one. Yes. I'm still waiting for the right answer. Please have a try. Okay. Pyari Jia. Yeah, perfect. Uh, yes, yes, yes. B, C, and D. Okay, computer program per se. What is that? Computer program per se not patentable. Clear? Discovery of any living thing not patentable. A clock having 10 hours and each hour divided into 100 minutes against natural laws, contrary to natural laws, not patentable. It is in section 3. So section 3 has certain subsection which says that something it is contrary to natural laws or theory are not patentable. So the B, C, and D not patentable. Then what about surgical instrument? Surgical instruments are patentable. Surgical methods are not patentable. But medical devices, surgical instruments are, yes, yes, these are patentable. So B, C, and D are not patentable, but A is patentable. Surgical instruments, yes, they are patentable. Devices have quite patents. So, but yeah, method of doing surgery is not patentable, like removal of certain cancer, medical or surgical procedures. These are not patentable. Instruments are always patentable. Okay, so answer is B, C, and D. So again, Rukaya Tasneem, you have also given the right answer. B, C, and D. So these are the multiple option correct type of questions. Here in OMR, you have to circle B, C, and D, all the three. Now, this is again the not. You will see that in paper you will get many questions in section 3. A new ester of a known medicine with a carboxylic acid chain is patentable if it shows significant improved therapeutic efficacy than the said acid, it shows higher melting point, it has a better solubility, none of the above. Please try it. Okay, first answer by Nidhi Shah, Himanshu Gogia. Okay, and Smita Khare. So all three have given the right answer. Answer is A. So three people have given the right answer, and yes, it shows must show significant improved therapeutic efficacy than the said acid. This is the only clause at which section 3D is passed off. Section 3D says that any salt will consider to be the same substances. So, but if the new substance has more efficacy in terms of bioavailability, then only patent could be permissible. Okay. So, yes, we'll proceed. Proof of right of patent must be submitted within how much time? 6 months, 3 months, 9 months, 12 months. Please try this. This is also a very important question. So, first answer has come from Jyoti Patil. I hope this is for this answer only. Smita Khare also. Nidhi Shah, Souvik Ganguly. Okay, so Kirti Rani Sharma, yes. Yes, you all are correct. Answer is 6 months. Answer is option A, 6 months. Proof of right to be submitted within 6 months of filing the application in India. Okay, try the another question. So, but uh, we hope I'm just switching to the paper two. So, I have given you some examples of single option correct, multiple option correct. Questions would be like that. But believe me, if you are remembering the Patent Act with a lot of interest and fun, it's so easy to understand that you will never forget it in your life. So try to apply in your all inventions, try to apply in your daily life. It will become much easy to understand, and this whole bare act will become very easy for you. So only reading will not be sufficient. Legal languages will sometimes trouble you, but try to understand those things. Don't need to write the exact language given in the Patent Act. Don't need to understand. Just try to find out the basic extract what is written, and try to remember the section and subsection number. Section 3 is very interesting. Even all sections you can really apply for the Patent Act. I just now switch over to the paper 2, because I consider that even paper 1 could be cleared by many. Paper 2 is normally difficult to clear. So we will now discuss with the paper 2, that is consist of 100 marks, and it is of 3 hours duration. So what is the structure of the paper? First we will see. Paper 2 will consist of also 3 parts. First part is of 20 marks, second part is of 30 marks, and third part is of 50 marks. So all questions in part A and part B are compulsory. Never leave any question, first of all. Part C comprises part C1, that is 20 marks, and part C2, 30 marks. So now what is part A, part B, and part C? Clear. So part C1. Part C1 is claim drafting. Always remember. Part C1 will consist of 2 questions, 2 long questions, and candidate is required to answer any one of them. Part C2 also consists of 2 questions, and candidate is required to answer any one of them. Clear? In case of candidate answers more questions than required, first attempted would be considered. You don't have time to answer more than one. Actually, even answering one question, 2 long questions become very time taking. So always save the time. I just wish to say that paper 2 should be written uh, in a very crisp way. Try to remember the section, try to write the section, because sections will give you extra marks definitely. And save some time for claim drafting, because in reading a big description even takes half an hour. Understanding takes about 15 minutes, and then you start writing. So what I suggest to you is like, let's come to the questions. Along with that we will discuss. So see, this is part A. Part A is containing 4 questions, short 4 questions, carrying 5 marks each, total 20 marks. Now see what they ask usually and how to answer those questions. So question is, A and B are co-inventor of a tracking device. Later, A files an application for a patent in his own name. B comes to know about this fact from the Journal of Patent Office, from a published patent. What action B can take to redress this injustice inflicted upon him by A? So, simple thing, A and B together invented something. A has filed a patent in his name. Upon publication, B came to know about this, and then how he can ask for justice. So, you have to apply the sections in which how the inventor is excluded, and now later on how the inventor could contact the controller to add their name as inventor. Very simple. You have to just apply this thing. What could be done by yourself? The same thing the controller does also. So what should be the answer written like this? If an application of a patent has been made with the exclusion of a name of an inventor, it is possible to intervene and seek redressal. When excluded, an inventor so excluded may make a claim to be included in the application under provision section 28 subsection 3 of the Act. So what does this Act state? So if you remember, what does it state? don't focus much on language, but at least write down the exact thing, exact fundamental that it describes. So it says that if any person or other than any person in respect to whom a request in relation to the application in question has been made under subsection 2 desires to be mentioned as aforesaid, means as an applicant, he may make a claim in the prescribed manner in that behalf. So yes, there is a provision, he can do that. First thing is that. So you have to say your client, yes, if your name is not there, you can definitely add it because section says like this. So now, how to make this? Such a claim for an inventor, the B can make by filling the form 8. So form number you have to remember, because then your client will ask which form have to be filled, what fees has to be paid. This is a very general question. So you have to say that you have to fill the form 8. So always remember, you have to say the remedy with the proper answer. So remedy must include form number and as well as the fees. So this thing you have to apply here. So form 8 and a payment of 800 rupees. And also the copy of statement and the claim uh, should be sent to the controller. Claim will be sent to the controller to A as well as to any person interested. Clear? Further, section 28(6) also stipulate that such a claimant be heard. जो भी claim कर रहा है, suppose somebody is claiming, that should be heard before the controller make a decision. The procedure of hearing should be as per the rule 60. So you can really apply here that you have to write the form number at fees, and whenever such claim is there, controller definitely inform the first inventor, because second inventor is claiming, he may be falsely claiming. So the notice must be given to the earlier inventor, inventor number A. So yes, controller has notified. Now both are really fighting. So controller hear both of them. So hearing is done, and hearing is done as per the rule 60. So normally in such cases, answer is like that only, that you have to remember the form numbers and fees. In such cases, whenever you claim for something, the notice is given to the earlier applicant first, and then both are to be heard. And depending on the merits of the case, decision is made by the controller. So in this way, you have to write a proper remedial answer. Now another question. These are all very small, so just write one small paragraph. Do not waste much time in writing this. Y owns an Indian patent. X requests for a license of a patent from Y. Y imposes certain condition that X cannot acquire such an article which are not covered by patent from any person other than Y. Y also imposes a condition of exclusive grant back in the license. So as an agent, do you think these conditions are appropriate? Please give your answer and relevant with like example of relevant provision of the Patent Act. Okay, so what to be said here? Patent Act clearly stipulates certain conditions to be unlawful whenever imposed by a patentee on a licensee. This is very, you can't impose like a very big sum in royalty for a license. There is a proper negotiation. If it is not done, even the licensee can approach the government. Government may also intervene for a license. So it cannot be imposed. So very simple, you have to just write that yes, this is unlawful. Condition mentioned above have found express mention as being restrictive condition that are to be avoided under section 140. So section 140 subsection 1 point A prohibits the patentee from regulating or restricting the purchase of article by the licensee. So it clearly instructs avoidance by the patentee from imposing an exclusive grant back. So this is written in Patent Act. So this is not allowed. So hence these conditions imposed by Y on X will be deemed unlawful. So definitely the licensee, if like grantee, patentee is not agreeing on certain conditions, the licensee can approach the patent office or even approach the government about it, and can go to the court, even high court, and can say that no, the conditions are unlawful, and but I want the license at certain negotiable conditions. So yes, the answer, but don't lengthen your answer much, because whenever you lengthen your answer, you have to give your justification with reference to the section and subsections. So patent examiner just want that you answer the asked question, and with proper justification using the subsection and section numbers. Don't much elaborate it, because it will just kill your time, do not give you much marks. Sorry. Now comes some long questions. An inventor has filed an application for patent in India and approaches you immediately thereafter for filing international application under PCT with specific questions on the following. So, inventor has filed an application for patent in India, right? And immediately approaching you that want to file the international application under PCT. So, this is a very general condition. Everybody after filing in India want that they should file internationally also. So, what are some questions? Whether he can claim priority of his application filed in India and within what time? First question. Another, where he can file a national phase application from PCT route. And another is, after filing of national phase application, what would be the fate of his previous application? Please advise him as per the provision of PCT and Indian Patent Act. So, what should be the answer? First of all, first question. To claim priority for an earlier application filed in India, an applicant has to file an international application under PCT within 12 months. So, international applications are normally in section 135. So, therefore, the earlier application will be treated as the basic application. So, first that he has filed in India becomes the basic. Within 12 months, he has to file international application. International application is always a complete specification with claims, never a provisional, and it should be done within 12 months. And international application can be filed on the site of WIPO or even IP India, because India is also a receiving office for international applications. So yes, easily you can answer. Now comes, where can he file national application from PCT route? So in accordance with the Article 22 of the PCT, an applicant can claim priority for an earlier filed application within 30 months of filing of the said application. So, suppose today I have filed a basic application. So, within 30 months, applicant can claim priority for an earlier filed application. Article 22(3) further states that national law can supersede the aforementioned national, because after 30 months they are entering the national phase. So national laws can supersede this aforementioned. In this light, Rule 24 of Indian Patent Act extends his time further by 1 month. In India, 31 months time are there. In other countries, 30 months are there. So within 31 months of the basic application, basic means first that is filed in India, the inventor can file his national phase application and claim priority from his basic application. So priority will be considered from the basic application. Priority is for deciding who is the first inventor. So it's a great advantage. So from his basic application, upon submission of the required priority document, he has to submit the priority document, that is filing documents, filing date, priority date, and it will be considered. So within 31 months, he can claim the priority. So yes, the question B is answered. C, after filing of national phase application, means you are entering the national phase after 31 months, what would be the fate of the previous application? Please advise him. So what will happen? So a request for examination has to be filed. So I think it's totally clear to all of you. If any doubt is there, you can definitely ask. So see, a request for examination under section 11B shall be made only for one of the applications filed in India. Section 135(3) says that. Therefore, in the absence of not filing a request for examination, the previous application shall be treated as withdrawn by the applicant as per section 11B. So suppose I am entering the national filing of national phase application, what would be the fate of previous is like you have to file the request for examination. If you are not filing the request for examination, previous application will be treated as withdrawn. So this is a kind of vague question. It's like, after filing the national phase, what would be the fate of previous application? Definitely, after filing the national phase, you have to get it examined. If you're not getting it examined, it will be considered to be abandoned. So definitely after filing, because in like a WIPO and PCT publication is already done within 31 months. So whenever you enter the national phase, the next step comes is the examination always. So if you're not going for examination, previous application will be abandoned. So these things you can really apply as common sense. Is like, after 31 months national phase, because I have already published during like 18, after 18 months in the PCT route. So what would be the fate is like, I have to directly go for examination of my patent application in national phase, otherwise it will be abandoned. So this thing has to be considered. So it is, you can just see here, answers are very crisp and just to the point, not very extended answers. So, what is being asked, if you are just writing the correct answer, because you are advising your client, and client is totally unaware of all those act and rules. So, you have to advise him rightly what is needed, what to be done. Like therapy. Therapist, what they do, they exactly see, give you the right medicine for the right disease. Do not give you anything else. So, like way, the answer should be this. Do not extend, do not write much, because normally in paper 2 people know the answers, know the claim drafting, but they have a shortage of time, because somewhere they write more than required. Now the question comes, write a short note on benefits provided for startups and small entities under the patent rules. As you know, this year G20 presidency is with India. This is a proud moment for us, and startups, especially startups and youth, are the major players in the scenario. So this, some questions over the startup and small entities will definitely be asked in this examination. Prepare that. So you can definitely write what are the benefits given to startups. So startups can avail the benefit of expedited examination at a reduced fee. They can this is the most important, 24C. Also, small entities and startups both are eligible, and they need to submit the details in form 28 about that they are startup. So what is a startup exactly? If you're fulfilling the criteria of a startup, you can, but here you don't need to write much about, like startup means they are a company which is DPIIT recognized, or which is involved in innovation and research, or not more than 10 years of incorporation, not more than this much of time. No, don't need to write this much. You have to just, you have been asked just what benefits given by patent office to startup, so just write that only, and write in a very crisp and clear way, because major benefit is expedited examination at a reduced fee. Expedited examinations are never being given to anybody beside startups, beside natural like inventors team with one female applicant. These are some of the other government organizations. So these are some criterias who fulfills the expedited examinations. So this is the most important one that you have to write. Okay, so one question from Nidhi Shah. What should be the ideal time spent on each part in paper 2? Okay, so I just want to say that for it is a 3 hour duration. The first questions that are consisting of 4 questions of 5 marks, you can just spend about 20 minutes time, not more than that. Just in 5 minutes, complete one answer. And whenever you come to the long answers, you can spend even 15-20 minutes in that. Try to wind it up in 1 hour. Try to wind it up. I'm not sure whether you could be able to do it or not, but fix a timeline of 20 minutes. It may extend up to half an hour. And for long answers, you have to fix a timeline of minimum 20-25 minutes. It may extend to half an hour. So 1 hour to 1.5 hours, it may be spent in your answers of answering the questions. Short answer as well as long answer. Not more than, and 1.5 hours should be the maximum limit. Now keep 1.5 hour for claim drafting. I just wish to tell you, because it takes time. But do not draft the claims earlier thinking that I should draft it and then come to questions. Never, because questions are equally important, and answering the questions whenever you have a fresh mind, because in answers to the questions you should mention the sections and subsections. and should have a very clear mind. You should remember everything, because after 2 hours, whenever you concentrate over or focus on many things, it may happen that your section and subsection may mingle it, even if you remember it very clearly. So first try to answer the short questions. Start in that way. Come in a tempo in half an hour. Then try to write the long answers with full like zeal, or with like full speed, so that you can complete it within like 45 minutes to 1 hour. Then 1.5 hour, let the time spent. Next 1 hour you have to spend on your claim drafting. 1 hour it takes, I said you, because normally it takes about half an hour to read the description properly. And then first you have to decide between two description. You will be given two description, you have to select any one to write the claims over it. And sometime it become confusing, because I am from, like, suppose biotechnology field, I am from mechanical field. My field, like, I have to choose the claims of my field. So do not think over it. Always decide based on that, how do you understand them more easily. So just have a look quickly for 5 minutes for both the description. Just forget it which domain you belong to. Just find it which is more interesting for you, which you can understand very easily, very well, in shortest duration of time. So in 5-10 minutes, first decide which option has to be taken out. Because sometimes we select an option and later on repent, no, this is not the correct one. So spend some time in selecting it. Once you have selected it well, just start reading it. I'm coming to that point exactly. So for next 1.5 hour, I'm switching over to the claims. So just first we will see that what are the answers. So here, this is a like a short answer. Now this is a long one. Some case study kind of questions will be there in the long answers. This is more easy to answer. Descriptive, but it will be more easy. Mostly these are section 3 based. Patentability based case studies. Normally they take up some cases already going on in Supreme Court or in patent office, and they give you as a case study. So some very important cases you have to prepare whenever you prepare for patent agent exam, such as Roche versus Cipla, Novartis case, Bayer versus Natco. These are landmark cases. Then Monsanto Bayer seed cotton cases. These are very such cases which are have landmarks in the history of patent system. So you have to just consider that such kind of cases must be gone through once, and you have to prepare such type of cases. So such question have been asked as a section 3D, is like a mixture of like esters, ethers, polymorphs, metabolite, pure form, particle size, isomers are considered to be the same substances unless they differ significantly with respect to efficacy. Now this particular question has to be answered with respect to a case study of Novartis Gleevec case. So what exactly has been done? So what I say to you, read the cases in a very interesting way. Find out exactly what has happened. See the section in which they are falling, and then write in your own words. Clear? So whenever you see such cases, just go through exactly what has happened. So I'm giving you a just very brief highlight what has happened in the Novartis case. Patent office has said that all are considered to be the same substances. What has happened? Novartis has filed a patent for imatinib molecule, that was a blockbuster molecule, Gleevec. When the patent was expiring, just before the expiry, some years just prior to that, they filed a patent on imatinib mesylate. Imatinib mesylate is just a salt form of the imatinib, and this salt form uh, was nothing but almost the same substance. And what uh, uh, what Novartis wanted is like, they want the evergreening of the patent by just filing a salt form of the patent of imatinib as imatinib mesylate, and again wanted a monopoly of 20 years. So Indian government, because in 2005 amendment section 3D has been launched, And as per this section 3D, they said that yes, imatinib mesylate is not considered to be patentable because it is just a salt form. So considering this, patent office rejected. Novartis filed long litigation to anyhow get the patent, but they didn't get it. So in such case, about 7 years long litigation went on. Later on, they didn't get the patent. So this is the case study. They approached the intellectual property appellate board. Earlier it was there, later on abolished, now in recent amendments. So uh, what has happened is like, so they fought to the supreme court level, and finally they didn't get it because like Indian government was very adamant. Chennai high court has rejected it. They were very adamant about it, like they will not give the patent because of that section 3D that was totally applicable. So this case study is all about the Novartis. So Gleevec. So this case is because it was earning more than 1 billion US dollar per year. So Novartis really fought the case as a long litigation battle. It became a landmark case. So you have to just write about something about this case study. So again, some like questions comes like this: A, invent a medicine which is a components made up of A, B, and C. Then component C is a powder of herb which is in the hilly terrain of Assam and adjoining areas. As a patent agent, advice: all things are means like is it really like patentable or not, and how to proceed for this. So some particular aspects. This is a combination. So combination is as per the not patentable as per section 3E of the Patent Act. So 3 says that a mere admixture obtained by aggregation of properties of substances are not patentable. So it was an aggregation. So to cross the patentability section 3E, it is necessary that this admixture is not just a mixture, but it has some synergistic effect. Otherwise, this is not patentable. So in this way, the answer has to be done. Another thing, herbal component C is a herb, so it is not normally not patentable. It may come under the like traditional knowledge digital library. So herbs are normally under traditional knowledge, so they are under repository which are considered to be known by our ancient people. So they are considered to be not patentable. They are in the public knowledge, ancient knowledge. So again, this is a kind of hurdle. Source of herb. This is also what is the source of herb. So permission has to be taken from National Biodiversity Authority, because they want what is the source, whether it is cultivated or purchased, what is the seed or the part of the plant it has, what it is used, whether it is suitable for use or not. So in this way, National Biodiversity Authority permission has also to be taken. So these are some of the points which are need to be considered and need to be applied while giving some advice to the innovator. So in this way, the answers are given, and then comes the uh, description. So one description would be given to you, and after description, uh, like this, or. So one full description. After that, one full description, you have to read it out 1 page, and then you have to draft the claims. So claims maximum, they say you to draft 2 claims maximum, and so you have to draft one independent claim perfectly, and then one dependent claim, but it should be as per the syntax of patent. So patent claim drafting is also a very important part, that you have to learn how to draft a claim, and the syntax at least should be followed. And independent claim must include all the components in broad way, and if some product benefit is there, that also should be mentioned in the independent claim. And dependent claim must elaborate the components properties or like components concentration in as independent claims. So in this way, you can draft the claim, and you can manage your answers in a short time, so that you can save your time and also you can answers. So I hope I have answered all the questions to you, and we have practiced very well answering the paper 1 and paper 2. So this session is an overview for you, so that to energize you for to prepare for your patent agent examination, so that you can exactly think over it. You can exactly prepare for your paper 1 and paper 2 both, so that you can clear both the papers with good marks, and later on can prepare for the viva voce also. So wish you all the best for patent agent examination. And thank you for your questions. It really helped all the like listeners present here. It was really very good interacting with all of you. So with this, I'm signing off. Thank you very much. So books are basically Indian Patent Act. You can Bear Act. You can study as a book, or uh, like even Narayana book is there. That is a big one about the Patent Act and rules. And basically, you have to understand all the act and rules, and solve the earlier question papers. So thank you so much. With this, I'm signing off. Thanks a lot.
Thank you, ma'am. Thank you. Really appreciate it. Your passion for teaching the patent agent course, it's unbelievable. Thank you. Always, it's very crystal clear. So, thank you, ma'am. So, folks who are still with us, I will just show you that we are going to start a patent agent session, and ma'am will be conducting the session from 8th of April. So, please, so I'll just quickly share one slide. And so, anyone who's interested in taking live sessions, so yeah. So I hope you can see my screen. Okay, so we will start the patent agent live sessions, Dr. Prachi Pandey. The starting is on Saturday, 8th April, and we will have classes every Saturday and Sunday, 7 to 8:30 p.m. So yeah, so 10 live lectures will be there, and Dr. Prachi ma'am, she will take the live lectures, so about 15 hours, 18 hours of content. There will be sample questions just like today. Every act will have sample questions. Every lecture will have sample questions. In total, the course will cover patent act, patent drafting, case studies, viva voce, and any questions you have for the patent agent exam. We will also share a few sample papers from the exam, which you have to do before the exam for practice, and even just to learn, and some other resources like patent forms, the whole Bear Act, and so on. So there will be access to all the live recordings and even some earlier recorded lectures for certain other sections we will make available for you. And we will also give a professional certificate by Turnip that you can add on LinkedIn to your licenses and certification section. And yeah, the price for people who have attended this webinar and for only until 31st March, it's 4990. So less than about 5,000 rupees. And it is only for webinar participants who registered with us and until 31st March. So the final price will be about 7,500. So if you want confirmation, if you want, you can, the payments will be made via UPI ID. Turnip@Kotak is the UPI ID. So if you want confirmations, even you can pay right away, and you can get confirmation. Just send a screenshot to any of these two: courses@turnip.co.in or WhatsApp at 98366 We'll send you one email regarding the same information that I've showed you here. And yeah, so if you're interested, by all means, consider it. And thanks a lot. Happy to have you for the session. I hope you enjoyed it and also learned a little bit. And wish you the best. Thank you. Have a good evening. And thank you, madam, for the lecture. Thanks a lot. Bye bye.